The defense attorney in your medical malpractice case wants to speak to your treating doctors. Now, in order to do that, he needs a permission slip from us in order to speak to them. What if I refuse to give the defense attorney that permission slip? What happens then? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. So now you've decided to bring a lawsuit against a doctor claiming that he violated the basic standards of medical care, causing you significant harm and injury. Well, now, during the course of the lawsuit, the defense has an opportunity to obtain your medical records from every single doctor, every single hospital you've been to. Why? So they can evaluate your medical condition. So they can evaluate the injuries that you suffered. And they're entitled to see all the medical records of every doctor, every hospital you've been to. But now, here's a twist. They say, you know what? We got the records. That's fine. We've had our own doctors look at them. But we want an opportunity to speak to your treating doctors. You see, years ago, the defense was not allowed to do that. In order for anybody to speak to your treating doctors about your medical condition, the only way that your treating doctor could actually speak to them legally would be if you, as the patient, gave this person permission, legal permission, to speak to them. That's the only way that your doctor would ever be allowed to speak to somebody else about your medical condition. So now you've brought a lawsuit seeking compensation for all the harms and injuries you suffered. Your medical condition is now an issue. The defense wants an opportunity to go ahead and speak to your treating doctors. And you know what they argue? They say, wait a second, Judge. The plaintiff's attorney, the injured victim's attorney, has had an opportunity to speak to the treating doctors. Why shouldn't we have the same opportunity? Simply because we are adversaries should not be the reason why we're not permitted to talk to the treating doctors. Now, you may have had conversations with your treating doctor about this lawsuit and about the claims that you're making, and the doctor may have told you certain things about what's strong in your case and what's not. And now the defense wants an opportunity to have that same conversation with the doctor. They don't know what the doctor's going to say. They don't know what the doctor's observations were other than what's contained in his medical records. Instead, they want to pick up the phone and say, hey, Dr. Jones, we represent this doctor who's being sued. We'd like permission to talk to you. Will you agree to give us a few moments of your time? So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.